Like a trusted turnout jacket you've had for years, Flex 7 outer shell fabric delivers a perfectly broken-in feel on the very first wear. Flexible, comfortable, and powered with the strength of Enforce technology, Flex 7 outer shell fabric is made to move. To learn more, visit tenkatafabrics.com/flex7. Flex 7, powered by Enforce technology. Only from Tenkata Protective Fabrics.
Breathing in diesel exhaust fumes is like walking into a fire without a mask. Over time, those toxins lead to cancer. Protect yourself with MagnaGrip, the easiest, most reliable exhaust removal system that features a true 100% seal to eliminate diesel exhaust fumes. To get free grant assistance, visit magnagrip.com.
IFSTA's Essentials of Firefighting 8th edition pairs trusted content with their latest research and includes a full suite of support products. Everything you've come to expect from IFSTA and more. It's essential content with unlimited customization potential. To learn more about this manual releasing in August of 2024, visit ifsta.org/essentials.
Well, welcome to Fire Service Court Radio show tonight. We have Chip Comstock, who's from Ohio and very famous there, of course. And then your host today is John Murphy, not so famous, but he is from Washington, the rainy state. Usually we have Kurt Verone with us and Brad Pinsky, and they're off doing sort of lawyerly things in the dead of night. So we're going to be missing those guys. And this is the first show off of our hot tour at FDIC, where we did probably the funniest law presentation ever in the history of law presentations at a little venue at FDIC called Live at FDIC, sponsored by Fire Subs or Firehouse Subs. Is that what it's called? Firehouse Subs, which we get a free T-shirt and no subs. And so maybe next year we'll demand subs and no T-shirt, because I already got one. And we've already got enough T-shirts as it is. One of the things that is so entertaining about the lawyers talking, and I'm not sure whether other presenters have this issue, but we don't really know what we're going to talk about until we talk about it. And then we know what we're talking about. So that's one of the great things about lawyers, is if we're sort of stumped for a solution, we dance a little, and then we finally come to the conclusion and move on to another topic, which makes what we do seem effortless and seamless. But deep down inside of us, we know it is total bullshit that we're presenting these issues so sometimes so glibly. But we do have a deep source, and not like deep throat like in the Watergate era, but we have a person who does a lot of research and is giving us the most current legal issues facing and challenging the fire service today. And I know that my cohort Chip has done some deep diving on the website, and we have some pretty, I think, entertaining topics and timely topics as it deals with some theft issues, which we talk about periodically. There's a big change coming in the FLSA rules for overtime and exempt employees, which does affect the fire service. And then just sort of a brief overview of the new updated pregnancy and lactation laws that we can't talk enough about, because it seems like every time we read about fire departments violating somebody's rights under the law, it's a lot of times it's women who are pregnant and then want to return to work and have to express milk. And so the departments just can't get it together yet.
As opposed to men who are pregnant and want to return to work?
Well, men can get pregnant. That's what the latest, when I journey through, used to be Twitter, now X, and God only knows what it is. Somebody says men can get pregnant. I guess I've watched Danny DeVito and Arnold Schwarzenegger in some of their movies, and there they were, pregnant and movie stars. I don't know how that all works, but anyway, without further ado, let's talk about pink collar crime.
Yeah, so trying to pick out some topics, and we purposely tonight decided that we're not going to go in depth. There are nights that we spend 45 minutes on one topic, and we thought we'd just pick a couple out tonight that seem to reoccur on a somewhat too frequent basis. And you hit it when you talked about pink collar crime. And again, you suggested earlier a lot of our great news sources is Kirk Verone's Fire Law blog, where he brings together all the latest topics that we have to that are out there on the legal front. Right. And so one of the recent cases, and again giving credit to Kirk, is that the treasurer of a volunteer fire department in Pennsylvania is now facing criminal charges for stealing over $90,000 from the department. The treasurer has been charged with forgery and theft by unlawful taking following a lengthy investigation by the Pennsylvania State Police. And one of the she was hired to serve as a secretary treasurer. The treasurer's responsibility included paying bills, making deposits, reconciling bank statements, making purchases via debit card. The annual audit conducted for the department disclosed that the bank account had been reduced to zero. The treasurer falsified bank statements, including removing ATM withdrawals from the statements. There was $77,000 in withdrawals in $500 increments. When the chief finally confronted the treasurer, she initially claimed she withdrew the funds to put it in a high yield fund, but could never document that fact. She later provided the department with a check for $76,000 in apology for removing the funds, and so forth. The investigation further revealed that she used the department credit card for personal purchases, forged the signatures of department officials on 2 occasions in order to request an extension of the loan agreement, etc. So there was approximately $3,000 in unauthorized debit purchases, $77,630 in ATM withdrawals, and $1,900 regarding cash sales of equipment not deposited in a bank account. And my favorite is $7,800 regarding cash paid for filled swimming pools. So missing. So, this is not unheard of. And I will tell you that a fire department in the county next to me, this is a public entity. They had to lay off every single police officer and just about every police officer and all the firefighters, because the township is missing approximately $1 million. Now they haven't. The fiscal officer has resigned. There's been no charges. There's been not the state auditors investigating. But that whether it's smaller or larger, $5,000. Again, we see this on a regular basis, and it's something that whomever it happens to, it's like, I can't believe that person did it. It's it's a surprise or shock to everybody when this does happen. And again, it's like many other things. Nobody thinks it's going to happen to their department or their town or village, city, municipality. Just their union. Just wouldn't happen. And I have my thoughts and comments about it, but John, I've been rambling. Any thoughts you want to throw in here at this point on that issue?
Well, I think one of and like you said, I think it's rampant. I think we have more sort of subtle threat or subtle withdrawals from accounts. People are stealing all kinds of stuff from the fire department, and only when somebody gets caught, it becomes a big issue. And then we talk about it in our shows, and we caution people against, like a single control checkpoint for all your money. And you need to have, I think we talked about, forgeries and those sorts of things, have, 2 signature checks, make sure you do running balances every month. And I know that, even like we said, there are some labor groups that, the treasurer has stolen pension money or trust fund money from their membership. I think a few years ago, there was a large theft from the department and somewhere in middle New York, wherever that is. that the treasurer stole about $13 million over a 10-year period of time. And I'm just flabbergasted at the amount. Like, how can we miss, that much, those millions of dollars in a department? But, the departments in New York have more money than they know what to do with. So why not, steal it and go off on extravagant vacations and buy awesome cars and horse tracks and all that other stuff. And I think it's, even though it's entitled the pink collar crime, there's a lot of men that do that as well. So it's not just gender specific, but it's opportunity specific. Is when you're in a position to manage money, some people just cannot control themselves. And I think we put in an inordinate amount of trust in people that do manage our money, the treasurers, the secretaries, and rightfully so. 99% of people are honest. It's the 1%ers that sort of get us in a jam and cause us to think. And I think as my new role, because I don't do retirement very well as a new fire commissioner. We just had a meeting last night, and our treasurer secretary runs, a monthly report for us, the deposits, the vouchers, the income, and and we're a pretty smart group of people. There's only 3 of us, but the state of Washington requires an annual audit through the state auditor's office. And so, so far, a majority of the departments have come out pretty clean. We too, like you, there's a city to the north of us that the city, I think she was the clerk. They discovered that she was having a relatively extravagant lifestyle based on a low salary, but was traveling, betting on horses, got new cars, changed her housing status to something that's a lot more expensive, way beyond her pay scale. And so, when they deep dive, I don't know is that true? Is that a word? Deep dive into her. How did she get here? It's like, oh my God, she's spending city money. And so we got to figure out how to prevent a lot of that stuff. So when you do bring on somebody that's going to manage your money, trustworthiness is certainly one of them. Some people, some organizations will do polygraphs, deep dive into background checks, prior crimes. But most of these people will come up squeaky clean, and it may be a first opportunity for these individuals to take advantage of your organization and basically, like Chip was saying, bankrupt us so we cannot provide essential city services. So
I think, you hit it on that, yeah, we should perform the background checks. You could look at a credit report on that employee, what's their background. But you're right. Most people are going to come up clean. And that's why they get away with it, because everybody trusts them, right? Everybody who embezzles is trusted. If we didn't trust the individual, we wouldn't give them the books. We wouldn't give them the right to write checks, because everybody knows that John or Sue, whoever, they would never do that. We can trust them. Right. And because they're trusted, they get away with it. They take a little bit of money, and then nobody catches them, and they take a little bit more money, and it continues to snowball, and they can't repay it back. Yeah. And so I think there's a really simple solution. Not going to solve every case, because there's some things that I've seen people do, and I'm not going to give ideas out here on the web.
We're not trying to make you a better embezzler, right?
Yeah, exactly. That's exactly it. But there is a thing that you can do to make it, at least they'd have to try harder. And that is this. This article I talked about, and what this treasurer did was she forged documents. She deleted stuff. She did this, she did that. And she was able to do that because she received the documents directly from the institutions. So if the person who's got the responsibility for minding the books, for managing the finances, for writing the checks, doesn't get the statements first, they can't fix them. So right. if you have a rule within your organization that the financial records or the online accounts can be seen by more than one person, or the bank statement come to the vice president or the secretary if they're separate, that you don't want people necessarily to have family connections. And I know in smaller departments that's hard, but you want to have the monthly statements received and reviewed by somebody other than the treasurer. And if everything looks fine, then they give those statements to the treasurer to pay the bills, reconcile, do all that other stuff. But if they saw that, hey, how come our account is, down $10,000, and what are all these $500 withdrawals from the ATM machine? Where is this money going? They could have stopped that early on in this case. And that to me is the simplest thing. And you just have to pass a rule. And, we don't want to do that because, again, we trust John, and, he's going to take offense if we suggest that we're doing this to prevent the embezzlement. And that's being naive. And it's, your job, if you're in charge, or even from the membership standpoint on departments that are private, is you need to protect the funds. Those are ultimately taxpayer funds or the public's funds, even though they may be a private account at the time. But everybody has an obligation to make sure they're safeguarded as best we can. And where one person is managing the books, that those funds aren't being necessarily safeguarded. So, my answer again is it's simple. Somebody else look at the books, but they have to get the statements first, because in this case, again, the treasurer was charged with forgery because they were all those the records were being doctored, and people might not catch that, especially with all the innovations that we can do with online, or using various programs to correct whiteout, do it, whatever you want to call it with records.
You're dating yourself with whiteout.
No, I thought that as soon as I said it.
Yeah, I agree. I think that's sage advice, because we're, like you're a fire chief, and then now I'm a new fire commissioner. We have, the ultimate responsibility to manage our department's physically responsible and to monitor, all transactions that go on, and to make sure that the balances aren't dipping lower than what we would expect based on bills we have to pay. And so it's just, I know that in our meetings, we get the treasurer's reports, which, link into the last month and a month prior to that. And so, and I think the sort of the saving grace for us is we have mandatory audits from the state auditor on an annual basis. And so there's somebody else taking a look at our books and deep diving into our accounts, and, we understand what's happening. So, but a lot of places, if you're running a private fire company or whatnot, there's no mandatory audit required. And so it makes it more opportunistic for people that want to, take advantage of their position and basically, somebody in the organization looking the other way or not paying attention to what's going on because they don't understand the finances.
Yeah, well, I'll tell you, I represented an auditor once that missed $1 million embezzlement. And that auditor got sued. That's how he got involved in the case. Now, I don't think the auditor, even if the auditor was doing his or her job properly, would have caught the fraud, because, again, it wasn't a super in-depth forensic audit. It was a general audit to make sure that everything lined up properly, purchase orders, checks, accounts, and so forth. And that's, I won't get into this very the scheme that permitted that type of embezzlement, because, again, that's one of the ways around that. So if somebody wants to be really creative, there are ways to do it, even to fool a state auditor. But again, that's not how most of the schemes are run. Most of them is just somebody who's writing checks to themselves or taking money out of the ATM or, whatever.
Dummy companies, dummy employees, dummy vouchers.
Keeping cash, right? So those are things. Again, if the state auditor is not going to recognize, for example, a dummy company, but local folks would say, if the vice president of the company is like, why are we writing a $500 check to, Acme, widgets? We don't need any widgets. So again, that's one of those. So I think we can, if you want, John, move on to the next topic.
I'm all about it. We're talking about pregnancy.
Well, I was going to talk about, sort of this. Let me give you the background. Again, kudos to Kurt Verone to bringing these to our attention. Three articles right in a row. First is the city of Nashville has been ordered by a federal court jury to pay Deputy Fire Marshal $250,000 plus attorney fees. Maggie Lawrence claims she was a victim of gender, race, and age discrimination when she was passed over for promotion. Next, I'll give it as Lynchburg Fire Department has prevailed in a gender discrimination retaliation lawsuit filed by a former female firefighter Master firefighter Mary Lynn Shoemate brought the suit claiming she was demoted in 2022 in retaliation for filing a hostile work environment bullying case. And last but not least, an Ohio firefighter is now suing. So we have one loss, one win, depending on your perspective. An Ohio firefighter suing her department alleging gender disability and pregnancy discrimination following the denial of her request for light duty assignment. All of these have, are protected classifications. We're getting into gender, race, age, which are, sex, military status, et cetera, that, all states have classifications which are deemed protected. And, some of the common themes here appear to be gender discrimination. And again, with the Ohio case, there's also pregnancy discrimination claim that's being made. And one of the things we talked about in Indianapolis in the show we did is that historical data shows, and we talk about this all the time, that with police, they get sued by the public. They get sued for improper search and seizure, excessive force, etc. Firefighters get sued by our own. We eat our own in terms of the lawsuits. The public doesn't sue us, firefighters sue us. And so we need to be really careful when we're dealing with personnel issues for those reasons. And again, if anybody reads Kurt's case summaries, you'll see that time and time again, the majority of the cases are firefighters suing their departments, the management, the municipality, whatever. And so we need to be careful. You need to consult with counsel. You need to have good policies and practices. But John, you wanted you mentioned as we went into this portion about the issues of pregnancy and some of the changes and things that firefighters or fire departments need to be on the lookout for.
Yeah. So first of all, I'll go back to what Chip was talking about. Civil rights have been around for over 50 years, right? So the legislation protecting those who are in the protected class have been on the books for a long period of time. Yet the fire service has a tendency to continue to violate people's rights, under the law. And so when you take a look at, how many lawsuits are out there affecting the fire service, they're mostly internally generated because we either violate our own policies or we don't have adequate policies, or if somebody files a complaint, we retaliate against them. And retaliation, if you take a look at the lawsuits that go on, and most of them will be at the federal level, retaliation is a huge issue, because Mary Jane may be just, harassed or pranked or, discriminated against in some form or fashion. And I file a complaint. I file basically a complaint internally and say, hey, this is behavior that's affecting me, and it's affecting my ability to come to work and do my job and all that other stuff. And they go, all right, well, we'll send you off, to a remote station. You won't have to face, any of the people that you're accusing of harassing you or discriminating against you, or we'll deny a promotion, so you're not in a position of leadership. And those are all, sort of retaliatory actions against, your minorities, women, people of color in your organization. But it also happens to men too. The predominant gender and race in the fire service is white males, and so we get an occasional case that a white male will file for discrimination or promotional issues or retaliation for supporting another member of the organization that may have filed a complaint. And so, those guys are filing lawsuits against departments as well. And so it's not just that we're focusing on one group. We're focusing, unfortunately, more so on one group, but all groups are affected. One of the things we did talk about at our FDIC Live broadcast, which I just watched it the other night on YouTube and was cracking up, and I had to message my two cohort attorneys in crime on that show. And I thought it was, when you looked at it, it was fun. It was brilliantly done, and we're very funny lawyers. And so in the information on there, not funny looking, but just, humorous,
John,
but not a stand-up comedy level. But one of the things we did talk about that we're seeing is as we try to, you know, um, take a look at more women in the fire service, there's going to be more women in your agency that are going to get pregnant. And so the Pregnancy Discrimination Act has been on the books for, again, a number of years. I think in the new law passed in 2022 was called the Pregnant Workers Fairness Act. And it just sort of reinforced and enhanced the protections that women firefighters have when they become pregnant and they want to go back to work. And so I think one of the most important things that we did talk about is that, we talked about the well-meaning fire chief saying, well, I want to protect, the firefighter and the fetus from undue harm. And so we're going to put the firefighter in light duty, which is discriminatory because maybe they don't want to go on light duty. And the bottom line in all of that conversation was there's two people that are involved in the decision to put the firefighter on light duty, and that's the firefighter and the physician. And so they'll make that determination of, a light duty position. One of the issues that we have is that sometimes, and I had a woman firefighter in my department that didn't want to go on light duty. And so we had to make the accommodations for bunker clothing, uniforms, all the things that we were required under a reasonable accommodation standard is to make sure that a firefighter had uniforms that fit, the firefighter had protective clothing that protected and fit. And so we had to make some, modifications. And then, she had her baby, took maternity leave. She came back to work. And so, so the second leg of the stool is, she wanted to express milk for her child. And so there's been a number of cases out there. And I think the biggest case that I always use is the Tucson Fire Department case, where they basically denied any sort of safe sanitary space for a firefighter coming back to work who wanted to express milk. And so they got sued. They lost. A lot of money exchanged hands. The firefighter kept her job, and everything turned out okay at the end. But it was a struggle to get to where they needed to be, where Tucson Fire Department and other fire departments resist this sort of post birth activity. And so there is a new law, again, that came out in 2022 called the Providing Urgent Maternal Protections, or called the PUMP Act. And it basically requires organizations to provide a safe, sanitary, lockable space that their employees can go to express milk and take time in order to do that. One of the things that we, as part of the act, is that under the FLSA, requires employers to provide reasonable break time for the employee, and it's compensable. And so you can't take them off the clock for the 15 or 20 or 30 minutes that it takes to perform, expressing milk. They still remain on the clock as active employees. And so organizations need to ensure that part of their policy package incorporates the new laws. And I think the Pregnancy Act's been on the books for a long time under the PDA, the Pregnancy Discrimination Act. The lactation issue, I think, has been under the law for a period of time under the ACA, or the Obamacare. That was one of the requirements that employees and employers, provide the safe space, but it has been violated so many times that I think that there's been a hue and cry from a population that required law changes. And so, and I am of the personal belief that litigation drives policy in organizations, and sometimes we're supposed to be pretty smart as far as chief officers and leaders, but sometimes we do the dumbest things that make your attorneys cringe. But other attorneys are smiling because you screwed up. So I think paying attention to what the new law is important. I think, as Chip said, consulting with your attorney on policy changes and updates, and can we defend this policy if we put it into place, is a conversation that you should have. But I think for those two, updates in the law are important. And as I wrote an article with Stephanie White from Fairfax, Virginia, on this very issue, my point was, why take an issue that's going to end in 12 months, pregnancy, and then, the post maternity leave and the lactation stuff, and turn it into a 3 to 5 year legal contest between your employer and your fire department. And so do the right thing on the front end, avoid litigation on the back end, create, happy times and a safe workplace for your employees. And I think, you set a new standard for your organization if you're proactive and smart about it.
I think that's really great advice. That it really is what we're dealing with is a short term condition, right?
Right.
In terms of pregnancy and everything else, and that it really you can make it be a much longer, much costlier matter if you don't try to accommodate. And that one of the things that I looked at is as you said, we've had a number of rules on the books that have tried to protect and to provide some accommodations to pregnant workers. And this law, the Pregnant Workers Fairness Act, went into effect last June of 23. So it's not brand new, but it's less than a year old at this point. And the main thing that people have to understand is it requires the employer to provide accommodations. It ensures pregnant and postpartum workers not forced off the job, and that they can get accommodations they need without facing discrimination or retaliation in the workforce. And that becomes a problem sometimes in the fire service because we are not traditionally set up to provide accommodations for women who may be pregnant or who may have to express milk, etc. And for good, bad, or indifferent, that may mean, depending on how the department's set up, that a unit, the company is taken out of service during that time period. And we're going to have to figure it out, because the issue now that's really different is we have to provide reasonable accommodations unless it would be an undue hardship on the employer, and the burden of showing the undue hardship is on the employer. So proving the exception, we have to be able to establish clearly from a management standpoint that whatever is being asked by the employee wouldn't work. And so that may be a lot harder. And as John said, from a practical standpoint, to the extent you can provide an accommodation, it's going to be a lot cheaper in the short term than it is the long term through litigation. And with the violation of these type of federal laws, it's just not paying the employee regarding the accommodations. Why John said some of the lawyers, the plaintiffs bar, the employees, attorneys are smiling is these laws permit the recovery of their attorney fees. So you're not going to be paying the worker, you're going to be paying a lot of money to the lawyers who bring these cases, and that's why they're willing to bring them. So I think that's what people have to think about, and do it before you have an employee who's pregnant. Talk about why we have to address this. You don't have to have accommodations that are 365 days a year if you don't have pregnant workers, but it's better to have the thought out when we do get a pregnant worker. If we do have a pregnant worker, how are we going to handle it? What's going to be our process? How are we going to do it? Going back to our FDIC program, which is available on YouTube, we spent more time in the details and weeds on that. And so again, we can talk about that, from restrooms and, bedrooms and everything else.
Closed hours.
And I was going to say, I will say this: if you say we don't have that problem because we don't have any, I repeat, we don't have any female workers, any female firefighters on our department, that is a whole nother subject, and that alone should just be a warning sign to you that you may have bigger problems than just worrying about the Pregnancy Fairness Act.
Yeah. I think a good resource too on these issues is the organization Women in Fire. I know that they've addressed the issues before. They have I think a good set of policies and somebody that they can point you in the right direction to get some advice as to how to implement these programs into your organizations. And it's an experience basically bad experience that we lessons learned, or good experiences the department did the right thing on the front end, and they had basically the smooth sailing and transition from pregnant firefighters to the maternity issues, the lactation issues, and at the end of the day, everybody's quote unquote happy.
So the one thing I'm going to just as a caveat, I agree with you 100% on the women in fire, and they've put up over the course of time a lot of sample policies, a lot of information, and I've not looked at their website in the last 6 months to see if older policies are up or not. Again, since they've been there for a while, I'm sure have continued to add an update, but just make sure that if you go to anybody's website or go online to use a sample policy, that policy reflects the recent changes. Again, June 2023.
Yeah, we lost Chip, popped right off. I'm sure he'll be right back. But he was saying that basically you want to make sure if you sort of cut and paste from website or online policies that they're all up to date, because I think sometimes we don't spend enough time updating stuff. And the second part is run that by your house counsel or your attorney to make sure that they understand how those policies affect your organization and how you can put together a program to accommodate, your pregnant workers or anyone else that needs some accommodations for either a medical condition or a pregnancy or an injury or that sort of stuff. I think one of the things that we're going to talk last about was the update in the FLSA, Fair Labor Standards Act, exempt employees. And so we're looking at, those sorts of things. And being that Chip is back, I segued into the FLSA exempt employee conversation, which I know that you're fully prepared to talk about. And that it's an important, I think, issue for the fire service, only because we've classified our workforce, I guess, as in the chief officer's rank, unless you're in the union, as an exempt employee, and the firefighters are non-exempt employees. And so and I know that as an exempt employee, when I was working as the deputy fire chief and the fire chief, we had a fixed salary based on a 40-hour work week. But everybody knows that we work 60 to 70 hours a week on projects and meetings and, alarms and responses and personnel matters. And so the 40-hour work week can turn into a 60-hour work week. And so what you were thinking you were making, making bank on your exempt salary, turns out that you're probably making a minimum wage at the end of the day or the end of the week, because you're spending so much time doing other activities adding to your already established work week. So the new rules, I'm going to let Chip sort of take over, but the new rules affect the exempt employee pay status and what, how do you determine what an exempt employee actually is? So.
Right. I mean, I think it affects two groups. The first is
well, thanks a lot, buddy, for blanking out on this one. So I think the groups that Chip was going to talk about. So anyway, so the 2024 new overtime rule, and I'm going to have to read this because I'm just catching up to it, because we got some issues in our organization as well, especially as a fire commissioner. Not that I'm the legal expert. I try not to do anything as an attorney. I just do it as a counselor, not as a counselor, but as a commissioner. We need to revamp, and we need to make sure that our organizations are up to speed with the new law, which Chip is going to talk about.
Well, again, I'm not sure what's happening on my end, other than perhaps this evening I'm using my phone, and whether I'm getting some other calls or texts and it's knocking me off, I apologize for our viewers. Quickly, from a career standpoint, we do have administrative exemptions that, as you said, you're not subject to overtime pay. And in the fire service, that relates to those people who make a certain dollar amount, and second, who actually perform firefighter work. And there was an issue of the city of Wilmington ended up having to pay overtime to 6 current and former battalion chiefs. The total payout was almost $460,000. and that was because they were classified as exempt administrative personnel. And I think the reality is that, without getting into all the great details, that they were probably not exempt under the administrative or executive exemptions. And so if somebody is working, even though they may have administrative duties, if their duties are primarily fire operational related, they are probably need to be paid in accordance with the FLSA overtime, hourly and overtime rules, which, again, as we talked about in the last incident or issue, not only will provide them with back pay, but also there's going to be attorney fees owed under the violation of federal law. Where it also gets interesting to me is that there can be arguments that smaller departments pay their chiefs some stipend, and if the stipend is relatively small, it may be under the FLSA volunteer status, where it's less than 20% what a comparable fire chief or firefighter might make. But when you start getting up into higher numbers, not the $2,000 or $3,000 or $5,000 a year, but when you make more money, you're going to have to make the minimum administrative exemption, and that minimum administrative exemption is going from approximately $35,000 per year to $50,000 per year. So on departments that are paying chiefs full-time or part-time status, and they're paying more than 20% of what a full-time comparable would be making, but less than $50,000, there may be issues there. And so the people are going to have to, the management, municipalities, villages, cities, private fire companies, whatever, are going to have to take a look at their pay structure to determine whether or not they are meeting the changes in the FLSA. And again, because there's some other changes that are going to go on that are going to go into effect this summer, this would be a good time to sit down on those issues with legal counsel and say, are we meeting the exemptions?
And also put into your policies and describing the duties and responsibilities of all your employees. And this is going to be important as well, because there's new OSHA rules that are coming into play here at the end of the year and next year, as to taking a look at upping your job performance. You're looking at job descriptions, and then how do you classify your employees as exempt or non-exempt, and then what's the responsibility and what's the duties of those exempt employees. And some organizations I know in the past have sort of classified what would be salaried employees as exempt employees, and boosted up people that are hourly employees into an exempt position, so they wouldn't have to pay overtime. And I don't think that's a real game that we can play anymore, as it deals with FLSA and the recent changes that are coming in, because there will be audits. I think people are not going to be happy if their status changes from an exempt to an hourly. But it makes you eligible, I think, for overtime. So there may be small advantages to that. And the FLSA actually classifies those that have decision-making processes as exempt employees. The hiring, the firing, the promotions, and those sorts of things, which your hourly employees generally are not responsible for or liable for under the overtime rules. The other part I think Chip was going to were the volunteers. It talks about under the new law that there's the minimum salary threshold, and so the sort of the narrative on the FLSA things, it says employees are only exempt from overtime pay requirements if they meet all three of the following. Their employee receives a salary. The salary is not less than the FLSA salary threshold of $43,000 a year, beginning in July 1st of 2024, and the employee has executive, administrative, or professional job duties. The new overtime rule also changes the annual compensation requirement for highly compensated employees from $107,432 to $132,964 annually, And so we're taking a look at all of the strata and structure in your organization and the compensation requirements that we're going to be seeing coming up this summer and into the fall. So the small business issues or volunteer departments, if you're paying a stipend, you want to talk to your attorney as whether the stipend payments or point systems or however you compensate your employees, especially in the volunteer arena, is how they sort of match up with the FLSA, because technically they are your employees, even though you may not want them as employees, but they still do, essential functions for your community and your service. And so you take a look at, how do you classify them in their job descriptions and their job analysis, and how they're going to be compensated for services provided. One of the things that we've always stressed, and I don't think this rule is going to be changing very much, is that you can't take somebody off duty. You can't take somebody off duty and have them participate doing the same job as a volunteer for no compensation. You're going to get a lawsuit on that one, and I think the back pay, the front pay, and all of the penalties that'll come along with it are going to be onerous for smaller organizations. So I think that the other part is, kind of capping your costs. And so organizations don't have unlimited money. And so overtime, exempt pay, compensation for your volunteers, obviously we all have budgets that we need to stay within. And I think one of the options for dealing with overtime rules is to limit the number of overtime hours your newly exempt employees can work. And so it's important that we kind of maintain and monitor the hours worked on compensated basis. And like I said earlier, we can't, if you still have the job done, you can't take them off the job and take them off the payroll in order to have them do the same work for free. And so, again, that's an illegality that I think that we will be facing, because people try to get creative and get work done. And that creates a hardship on the organization, and certainly for your attorney. So so I think, and then the last thing is that I think we need to have a conversation with your employees of the new rules, because some of their statuses may change, and so they may come from an exempt to an hourly, and it makes a difference. And then the salary threshold is the other one, is that you may not make as much money, or you may make more money under the new rules. But basically, when we talk about those sorts of things, that should be a conversation as the organization gets their act together and gets their policies in place, and all the employees are aware of what the new FLSA changes are. Chip.
Well, again, sorry for the technical difficulty on my end. I cannot explain why I cannot get connected on the other, but then it popped up on this. I'm using a different computer. So
you guys are blaming me for my crappy connectivity out here in Washington. So.
Yeah, well, it's definitely on me tonight. But again, we were trying to cover three subject matters, and I filled in, John, as you're listen to the end as you're providing advice, again, talking to the employees and understanding, looking at those issues. And I think tonight's main issue for us was to recognize, hey, you may have issues of embezzlement. You can fix that easy. We want to eliminate gender and other discriminatory practices up front, so we don't run into problems down the end. Talk to your counsel, be aware of things, and make accommodations, right? Because it's cheaper in the long run, particularly with pregnancy. And then in the FLSA, be aware again that there's some changes that are coming up, and that people should be aware of those and check with their attorneys and with the administration to make sure that they're in compliance. So, this was primarily just a quick overview tonight, not spending a lot of time on one topic, but trying to address three separate topics. Give everybody just a little overview. So again, just more of an awareness level that people should to take a look at things and prevent the problems up front. I know we like to talk to longer, but usually we talk about Mrs. Pinsky, our number one fan, being out there. I've never really spent a lot of time, but mentioned my wife Jennifer. It is, as I said before we began, my my wedding anniversary tonight. Many years that she has put up with me. And so I'm going to we'll finish this up or wrap this up about 1 hour in, so I can go have dinner with the lovely Jennifer Comstock.
Well, congratulations on your anniversary, and I think that you need to attend to home business, and we appreciate you taking the time out and having your lovely wife let you go. I'm sure she's calling you now. That's why you're getting kicked off the air all the time.
Yeah,
like, let's go dinner.
She's downstairs and disconnecting the internet. I'm sure that's what the problem is.
I'm sure. So without further ado, congratulations to Chip Comstock and his wife. And until next time, be legally safe out there. And thank you for taking the 50 minutes of your time and listening to us. Fire Service Court Radio. Thank you.
Like a trusted turnout jacket you've had for years, Flex 7 outer shell fabric delivers a perfectly broken-in feel on the very first wear. Flexible, comfortable, and powered with the strength of Enforce technology, Flex 7 outer shell fabric is made to move. To learn more, visit tenkatafabrics.com/flex7. Flex 7, powered by Enforce technology. Only from Tenkata Protective Fabrics.
Breathing in diesel exhaust fumes is like walking into a fire without a mask. Over time, those toxins lead to cancer. Protect yourself with MagnaGrip, the easiest, most reliable exhaust removal system that features a true 100% seal to eliminate diesel exhaust fumes. To get free grant assistance, visit magnagrip.com.
IFSTA's Essentials of Firefighting 8th edition pairs trusted content with their latest research and includes a full suite of support products. Everything you've come to expect from IFSTA and more. It's essential content with unlimited customization potential. To learn more about this manual releasing in August of 2024, visit ifsta.org/essentials.